Hello everyone, welcome to my channel. Have you ever wondered what happens if an overseas Vietnamese sends money home to buy land but asks a relative to stand on the title and then a dispute breaks out? Actually, this is a very common and complicated situation. Today, we are going to dive into the case law No. 2, 2016 AL to see how the law handles these trust-based deals. The reason this case is so significant is because it establishes a very fair principle for these exact situations. Instead of only looking at who paid the money, the court now officially recognizes the effort of the person holding the title. They look at how the person managed, preserved, and enhanced the land's value. And here is the golden rule from this case law. If the court cannot determine the exact value of those contributions, the increased value of the land will be split equally between the buyer and the title holder. Now, let's see how this rule applies to a real-life drama involving a sister and her brother. In 1993, Miss Nguyễn Thị Thanh, a Vietnamese citizen living in the Netherlands, returned to Vietnam to visit her family and decided to purchase agricultural land in Sóc Trăng province. On August 10, 1993, Miss Thanh personally negotiated the transaction and paid 21.99 TOs of gold to purchase 7,595.7 square meters of farmland from Mr. Hành Tinh and Miss Lý Thị Sa Quỳnh. Because she was residing overseas, Miss Thanh asked her younger brother, Mr. Nguyễn Văn Tám, to stand in her name on the land transfer documents. After the purchase, the land was handed over to Mr. Tám and his wife for cultivation. However, the dispute arose years later. In 2004, without Miss Thanh consent, Mr. Tám transferred the entire parcel of land to Minh Châu Co. Ltd, receiving 1,260,000,000 VND. Believing that she was the true purchaser of the land, Miss Thanh filed a lawsuit demanding that Mr. Tám return the full amount of 1,260,000,000 VND. During the proceedings, the parties presented sharply conflicting arguments. Miss Thanh argued that she directly negotiated the deal and paid the gold, while Mr. Tám merely held the title on her behalf. Therefore, the proceeds from the land sale belonged to her. Mr. Nguyễn Văn Tám claimed that he and his wife paid for the land themselves, legally held the title, obtained a land use rights certificate, and thus had the lawful right to sell the land and keep the money. He also alleged that the land transfer document produced by Miss Thanh contained a forged signature. Meanwhile, the original sellers, Mr. Hành Tinh and Miss Quỳnh, confirmed that Miss Thanh was the person who paid the full 21.99 TOs of gold, and that Mr. Tám stood in name only at Miss Thanh request. The case went through multiple levels of adjudication. The first instant judgment in 2006, Mr. Tám and his wife were ordered to return 630 million to Miss Thanh. And then the appellate judgment in 2006, Mr. Tám was ordered to return only the equivalent of 21.99 TOs of gold, while more than 1.23 billion VND was ordered to be confiscated and paid into the state treasury. Finally, in the Cassation Review 2009, the Chief Justice of the Supreme People's Court filed a protest, stating that both lower courts had committed serious legal errors. Upon review, the Judges' Council reached the following conclusions. There was sufficient evidence that Miss Thanh paid the purchase price, while Mr. Tám merely held the title on her behalf. However, Mr. Tám contributed labor and effort in managing and maintaining the land, thereby increasing its value. Accordingly, Miss Thanh was entitled to recover her original investment of 21.99 TOs of gold. The remaining increase in value should be treated as joint profit and divided between the parties based on their respective contributions. Confiscating the entire increase in value to the state was contrary to the 2005 Civil Code. In addition, the lower courts misidentified the legal relationship, as this was a dispute over ownership of money, not merely a claim for recovery of property. For these reasons, the Judges' Council decided that both the first instant and appellate judgments were annulled. the case was remitted for retrial in accordance with the law. That is the end of this Case Law No. 2, 2016 AL. Thanks for your watching and see you in my next video.